Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in one of my previous class we have discussed treaties and conventions as a source of international law. This is a comprehensive approach to understand the concept of treaty. We are going to discuss the meaning and definitions of treaty, the classifications of treaties, few important facts about treaties, the essentials for a valid treaty, and we are also going to discuss few important forms of treaties. Why to waste time? Let's get into the first slide. Let us start the discussion by understanding the meaning and discussing few important definitions on treaty. The simple meaning for the word treaty is it is a formally concluded and ratified agreement between states. Now the states will have a discussion, they conclude on few points and then they ratify it, and when I am saying states, it may not be only two states, it can be multiple states also. That is one factor you need to remember. Now, when it comes to definition, I will start with Opinium's definition because he has covered every single point when it comes to treaty. He says international treaties are those agreements between the states which are of contractual nature and produce legal rights and obligations. What a beautiful definition. He covers what is it, between whom, what is the nature, and what it produces. He starts by saying it is an agreement. When he says it is an agreement, there must be offer and there must be acceptance. Between whom? Between states. It need not to be only between two states. It can be between multiple states also. And which are of contractual nature. The moment it becomes contractual nature from agreement, there is legal obligation, and that is what he covers in the last part by saying it has legal rights and obligations. I don't think anything can cover more than that. Schwarzenberger says treaties are agreement between subjects of international law creating a binding obligation in international law. When he says subjects of international law, it is mainly the states. So treaties are agreement between the states. That is what you need to remember, which creates a binding obligation in international law, which is what Schwarzenberger has to say. The Vienna Convention on Treaties 1969 beautifully says treaty means an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments. There is a lot of aspects in this particular definition which says it is an agreement which is concluded between the states, and this is in written form, and this will be governed by international law, and finally it can be embodied in a single instrument or maybe two or more related instruments. That is all about the meaning and definitions of treaty. Then comes the classifications of treaties. Opinium says there are two major classifications of treaties, the lawmaking treaties and the treaties made for other purposes. Then we have Vettel, who says there are four major classifications of treaties: the equal treaties, unequal treaties, the real treaties, and the personal treaties. Among the classifications of the treaties, the most interesting classification is coming from Starkey, who divides the classifications of treaties based on forms of treaties. He says it can be between heads of the states, which is mostly of political in nature, or it may be between the governments, which is mostly of non-political in nature. He says treaties can also be formed by representatives of state or the ministers of the state or the government departments of the states. Justice M.C. Nair classifies treaties as treaties having the character of conveyance, treaty contracts, or lawmaking treaties, where he discusses two important subcategories: treaties creating constitutional law, just as Charter of International Court of Justice, or pure lawmaking treaties like labor conventions negotiated by ILO. These are the few important classifications that you can think of when it comes to classifications of treaties. Here I am bringing few interesting facts as far as treaties are concerned. The first being the first nation-to-nation treaty in modern days happened between the New France and 40 other First Nations from North America, which is known as Great Peace of Montreal, which came into existence on August 4th, 1701. The second interesting fact is British Empire signed more than 56 land treaties with the peoples of Australia, the United States and Africa between 1760 to 1923, and treaties are mostly in the language of the more powerful nation, and treaties are different from each other based on the context and the states. And finally, treaties earlier were very simple, but nowadays treaties are very detailed. Sometimes treaties can be more than 1000 pages also. Then comes the essentials of a valid treaty. For any treaty, the first and foremost requirement is appointing the right persons for discussing that particular treaty is very important, which can be called as accreditation of persons on behalf of contracting parties. Then there will be negotiations. Once the negotiation is over, then the third point, they will give signatures on the basis of free consent, and once all of these are done, there should be clear adoption of that particular treaty. Once the appointment is over, once the negotiation is completed, once the signature is put and adopted, then comes the accession and adhesion, where both the parties need to adhere to that particular treaty. That is what we can call as the fifth stage, where there is enforcement of a treaty. And then if there is a registration and publication as per the Article 102 of UNO Charter, in such case, if there is any dispute with the treaty, then UN will take such cases. If it is not registered under the Article 102 of UNO Charter, in that case, UN will not take such cases. You cannot refer such cases to the UN unless and until the treaty is being registered under the Article 102 of UNO Charter. The last thing here is basis of binding force of the international treaties. There are many principles like doctrine of pacta sunt servanda. I have made an independent video on pacta sunt servanda. You can go through it. Then comes the forms of treaties. The first and foremost important form of treaty is convention. Convention is basically between many of the nations, and it is just one class to treaty because there may not be 100% of implementation possible when it comes to convention, whereas in treaty it brings both legal rights and obligations. The second form is protocol. Protocol is the original draft of a diplomatic document. It is the final draft, it is the original draft which is of a diplomatic document, especially of the terms of a treaty agreed to in conference and signed by the parties. It is also one less than a legal treaty. The third form of treaty is agreement, which is a negotiated and typically legally binding arrangement between the parties as to a course of action. Now, agreement is also not 100% legally binding activity like treaty, but this is also one form of treaty. And the fourth one is arrangement, which is just an understanding between the states. That is also one form of the treaties. The fifth form of treaty is process verbal. Whenever there is a lot of proceedings happens, there will be a written report for the same, and when you are maintaining such written reports, that is known as process verbal. And record of terms of an agreement can be called as process verbal, and this is also considered as one of the form of the treaty. The sixth one is statutes. I need not to explain too much on statutes because a written law passed by a legislative body is known as statute, and we being student of law, we all know what is a statute. That is also one of the forms of treaty. The seventh form of treaty is a formal or explicit statement or announcement, which is declaration, and eighth one is modus vivendi, which means way of living, which is an arrangement or agreement allowing conflicting parties to coexist peacefully. Now, if there are two parties which are not having right spirit, they have difference of opinion, in that case, if there is an arrangement made to have an agreement allowing conflicting parties to coexisting peacefully, then that is known as modus vivendi. And the last one is modus operandi, which means a particular way or method of doing something. So that is the last form of treaty. With that, I am concluding this particular presentation. What next? I will come up with another interesting topic from international law. Till then, thank you so much for all the messages that you have sent to me. Thanks for clicking the likes button. Yes, here and there I can see few dislikes also. I will keep working to improve the quality of my video along with the contents and other stuff. Thanks for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are watching my channel, and thanks again.